It is it is my pleasure to be the moderator today for this webinar. And this webinar is about contemporary issues on open licensing and copyright. So for having a little bit of a background for this webinar, open licenses are one of the most important innovations in copyright law. Like copyright itself, however, open licenses can be more complex than they first appear. What happens when someone uses your openly licensed material to do something you didn't anticipate and didn't approve or don't approve? What is the impact of open licensing on the use of copyright work to train so-called artificial intelligence tools? Have open licenses been successfully enforced in court? What lesser known provisions in Creative Commons licenses might help authors embrace their use? So basically today we will have an exploration of contemporary issues in open licensing and copyright. And our expert today, we are very pleased to have Brandon Butler. He is a copyright lawyer and expert on the lawful use of archival materials. From 2016 to 2024, Brandon was the Director of Intellectual Property and Licensing at the University of Virginia Library. Previously, he was the practitioner in residence at the American University Washington College of Law's Samuelson Glusko Intellectual Property Clinic, where he taught courses on copyright and fair use and supervised students' attorneys in the representation of artists, filmmakers, publishers, authors, and entrepreneurs in a variety of intellectual property matters. Brandon was also the director of public policy at the Association of Research Libraries, where he advocated for fair copyright and intellectual freedom on behalf of the nation's most prominent academic and research libraries. Wow. Brandon graduated from the University of Virginia School of Law and was an associate of Dow Loans LLP, later merged with Cooley LLP in Washington, D.C. Brandon is the law and policy advisor to the Software Preservation Network and is an advisor to the American Law Institute's Restatement of the Law, Copyright. He is on the editorial board of the Journal of Copyright in Education and Libraries and is the author of a variety of journal articles and book chapters about copyright and fair use. In college, Brandon was the local music reporter for Athens GA Alt Weekly, The Flagpole, and he took a semester off to tour the country as a substitute guitarist in his friend's punk band, Whippersnapper. Brandon is admitted to the bar in Washington, D.C. So with all of that amazing information about Brandon, we know he is the best person that can guide us for our topic on contemporary issues today. It's on open licenses and copyright. So I'm passing so proudly my part to Brandon for him to talk.
Wow, whippersnapper. I forgot that was in there. Go Google whippersnapper. You won't find much. Yeah, I'm thrilled to be here today, y'all. And fair warning, the topic evolved a smidge since we wrote that summary. And I hope you won't mind, but generative AI continues to sort of eat the world. And so I felt like if you can't have any copyright conversation without talking about it. And I think that's actually appropriate. I think it's too important to leave it out. So I'm going to start today. Well, first I'll say it's very good to be here. And it's lovely to see so many friends and familiar faces and names in the room. And the as you can see from the sort of title, I'm managing expectations here. Not only am I going to talk about generative AI, I'm only talking about those things as far as we know them today, literally February 6th, 2025. I make no promises about tomorrow. More so than ever, it feels like that is a fool's game. So, but I'm going to try to help us understand maybe a little bit about where we are today, and where things could go, if not where things will go in the future. So here's the roadmap. I want to say a little bit about who I am these days, and what I'm up to so that you know where I'm coming from. And then I'll say a little bit about generative AI, with a little bit of the overview of the law, but also, frankly, some politics, which is part of my job these days, the politics of AI, and why I think the academy and particularly academic libraries should continue to be engaged and frankly, how to put it, aligned with the arguments about fair use in generative AI. And then I want to talk some about OER and scholarship, and open licensing, I should say, and speculate about how those things will interact with generative AI in the coming years, perhaps irresponsibly so. But since I told you I'm going to be irresponsible, you can't blame me. And it's the only responsible thing to do is to warn you when I'm about to be irresponsible. So who am I now? I ask myself this every day. Right now, I am at least two things and maybe three. One thing I'm up to is I'm the executive director of a group called the Recreate Coalition. And Recreate is a kind of, and I'll date myself here, but I think of it as the Voltron of fair use, or maybe the Captain Planet of fair use for all us Gen X kids. What that means is all of the different groups who are interested in defending fair use and fair copyright, whether they're library groups like ARL and ALA, or they're civil liberties groups like the EFF and Center for Democracy and Technology and Public Knowledge, or there are our friends in private industry, the CCIA, which is sort of the trade association for the technology industry, or startups. There's a group in the Recreate Coalition called Engine, which represents startups. And all of those groups have lots of different interests, and they're sort of, pulled in different directions. I know ARL is very busy with lots of non-copyright stuff right now, as they should be. But they all do share an interest in copyright, and Recreate is where they all come together and speak with one voice when possible, because it takes like 12 groups saying something in favor of fair use to begin to counteract the power of the Motion Picture Association saying the opposite, right? Or the Recording Industry Association. So we need strengths in numbers, and that's what Recreate tries to provide. So I'm excited to be leading that group. And that's about 50% of my time. The other 50% is spent running a law firm with my friend Peter Yazzie called Yazzie Butler PLLC. And in that law firm, we focus on fair use and we advise all kinds of folks, but primarily filmmakers, on how to use fair use in their work. And it turns out that most documentary film, reality film, reality-based television, all that stuff kind of couldn't exist without fair use. It would be impossible to make those kinds of stories. Right now, I can recommend, if you're not watching it on PBS, Migrations, the Henry Louis Gates, his latest series. We worked on that. That's an example of the kind of work we do. And it's just chock full of fair use and chock full of archival materials. And this is where my world's kind of, there's a continuity in my career, because most of my clients are working with archivists to find materials that are relevant to the stories they're trying to tell. And so I'm still very lucky to be advising folks on how copyright applies to things you find in the archive, things you find in the library, and how you can use those materials. But, my clients these days are just different kinds of clients, but it's the same kind of work. So I love it. And then, I still find time to like make bread. That's my attempt at baguettes, which came out all right. But I'm still learning. So that's sort of where I am these days. So my first big topic for this morning is generative AI. And apologies, because by now some of this will probably be familiar, but I feel like it's the kind of thing that you can't hear enough, and that the more you hear it, the more you'll understand it. So I hope this isn't too much of a review, but I think it's important. And my thesis is right there in the subtitle. Why is this a fair use, and why should you care? And I'm revealing my priors there. Training an AI model, I believe, is very, very often a fair use. That is, it's protected by the fair use rights that exist in copyright law. Why are we talking about fair use? Well, the way you train an AI model, of course, and this I'm sure we all know at this point, more or less, is by exposing the model to metric tons of existing culture, just as much as you can get, right? And what the model is doing is learning how to predict the most likely correct response to different kinds of prompts. And the more data you can see, the better you are at predicting what is the correct response to a prompt, right? What is the most helpful way to give people what they ask for when they ask a question of an AI tool. And so it takes a lot of data, and almost all of the most useful data are in copyright. So occasionally you'll hear people say, like, oh, you could train this stuff on public domain materials. Well, only if you're not going to ask it to do, only if you're not going to ask about anything after 1929, right? Only if you're going to, if you say like, well, so ChatGPT, what's the best way for me to get to France? And if you want it to tell you, we'll take a steamship, and make sure you arrange to have your children, cared for in a work camp. Those are the kind of answers you're going to get from a machine that's trained on data from 1929 and before. So that's silly, right? So you need sort of recent data in order to get useful outcomes from these machines. And in fact, we know we just know there's been enough litigation now. There's, multiple cases happening, dozens of lawsuits. We know that all the big mainstream models were more or less trained on the entire internet, right? Every publicly accessible website, and then probably some not so publicly accessible websites, depending on which model you're talking about. Um, and so copyright is just at the heart and soul of all this stuff, because all that copying at that scale couldn't happen without some kind of a copyright alarm going off, right? And so the fundamental question that all of this prompts us to answer is that okay? Can that be legal? How can that be legal? And you see a lot of the discourse about AI sort of assumes that it can't possibly be legal. And you see things like, words thrown around like theft. They're stealing my content. And I submit to you that whenever you hear somebody call something theft, you should immediately get suspicious because that, as the old saying goes, reach for your wallet because somebody wants your money. When they say that's theft, what they mean is you need to pay me. And so that's what's happening. A lot of people are saying when AI is trained, that's theft. And we have to sort out whether that's true. And if we don't, there'll be very grave consequences. So how do we figure out whether it's okay to train AI materials with in copyright materials? And there's really no way to sort out this question again for in copyright materials. We could talk about, and we'll talk about open license materials as training, and we'll talk about, and public domain materials, of course, would be fine. But again, given that these machines sort of need so much data, you're going to have to use in copyright materials. And the best way to answer that question is with fair use. And if you've ever heard me talk, then you've probably heard me talk about fair use because it's the thing I most love to talk about. I'm going to do it again right now. Fair use is a user's right in the law, right? It belongs just as it is just as important as the copyright, the exclusive rights that are initially granted to authors. Fair use rights are granted to everyone. And fair use is a kind of a four-factor balancing test in the law. Courts aren't told, well, fair use means 30 seconds of any audio work or 20% of any video work. There's none of that in the fair use statute. What fair use essentially tells judges is you have to look at each case and weigh these kind of equitable factors, right? And the four factors in the law are not super helpful, actually. That's another reason, it's dangerous to try to be a textualist about the law because a lot of the text of the law is not as helpful as you want it to be. And the text of the fair use statute is not super helpful, but that's okay. Fair use evolved over time based on judges saying on a case by case basis, this is the kind of use that should not require permission. And in a way, that's sort of the heart of fair use. This is the kind of use that should not require permission, um, either because it's very socially beneficial, it's part of part of how we have a democracy. It's important to free expression, and typically, there's not the right kind of harm to the copyright holder, so the public benefits and the copyright holder, they might wish that they could make money off of this particular use because everybody wants to get paid for everything all the time. But in fact, if this use isn't paid for, it'll be okay. The copyright holder will still be able to sell their own work and make a living, even if this fair use is permitted. Um, and in fact, the courts have distilled this idea of fairness and sort of public benefit and so on into a core concept called transformative use. And so a use is transformative when it serves a fundamentally different purpose from the original purpose of the work and makes it possible to create new culture that is a benefit, new knowledge, new understandings, new insights, and so on. So some paradigm cases of traditional sort of transformative fair use are criticism, right, and commentary. So this is why fair use is so important for scholarship. If I'm a scholar and I need to say, well, I think that this particular part of this essay is fundamentally flawed, and here's why. It's infinitely more useful and honest for me to be able to quote that part for you so that you can see it, so that you know what I mean, so that I'm accurately representing the thing that I'm critiquing and so on. So, and yet, my critical essay is a new contribution to culture. It's a new work that didn't exist before. And to the extent that it contains some expression from the previous work, that's okay because my work is a new work and it's not an unfair substitute for the old work. It's a new work, right? So, in the context of academic libraries, I'm sure y'all will remember fondly, those of you who've been around a little while like me, fair use became very important in the digital age with the Google Books and HathiTrust cases, right? And I think those cases are really important, and they're back in the news now because the principles from those cases are really the heart and soul of what's going to be debated in all of these AI lawsuits. And so the it's important to understand the basic analysis in those cases was that because both Google Books and HathiTrust they involved the digitization, making millions of copies of books and creating a kind of database of all those millions of books, and then using that database to generate different kinds of new knowledge, right? So you have this database, you could query it and you could say, you could find find books that are relevant to a particular idea by searching through the database. That was what Google Book Search's core sort of use case was. HathiTrust similarly could sort of tell you where does your query appear in books. But also we had, things like Google Ngrams where the database could tell you trends across multiple books and say, well, this is how this word was used in, the 19th century, but you can see that it became much more popular to use this word in the mid to late 20th century. So you could query again this whole database of books and learn new facts about the history of the written word that you couldn't know without having first created this database. And that the buzzword that Judge LaValle used a lot in his opinion in the Google Books case in the Second Circuit, where he ruled that this was a fair use, was that this increases public knowledge. It took all of the knowledge that was sort of factual that was available in these books, but sort of locked up, as it were, in the copyright and made those facts available to the public without revealing so much of the book that it was essentially, would be a piratical substitute, right? You could only get snippets, you could only get, portions that would help you understand the factual answer to your question. You wouldn't get a replacement for the book. I would argue that generative AI tools fit this pattern very well. That is, the logic of the argument is that there is information available in this corpus of books. How popular was this word? When was something first mentioned in the literature? How many books include a passage that addresses this topic? What are the books that contain passages that address this topic? Those are all facts that don't belong to anyone. In fact, facts are free for all. And so creating a tool that lets you pull facts out of a body of knowledge is a fair use under those cases. And I think that's essentially what artificial intelligence tools allow us to do. That is, what they learn by training across a corpus is factual information. That is, how often is this the right answer to that question? How do I write a sentence how do I write a sonnet? How do I write, a haiku? How do I write a recipe? Those don't belong to anyone. Those are facts, those are ideas, those are abstract concepts. And the machine just has to read 100,000 haikus to learn what a haiku is, right? But knowing the knowledge that results is free of copyright. Um, and I think this is a really powerful idea that you can learn knowledge by analyzing a database of data, and extract those facts. And I think that's a powerful idea that the Academy has a strong interest in. So this is why I think you should sort of care about these cases and that you should, in some sense, root. And I realize there are other issues with AI and AI companies, and there's lots of good reasons to want to regulate them or to ensure that they're acting fairly and justly. But in terms of copyright, I think you should be rooting in some sense for fair use to win the day, because otherwise the blowback effect of a bad fair use opinion for scholarship could be serious. If AI training is an infringement, it's not clear to me how the rest of the HathiTrust opinion continues to be good law. Because again, the essence of the HathiTrust opinion was that, it's okay to crawl across this giant database of in-copyright material because what you're doing is learning new facts and generating new works. If AI can't crawl across a database of material in order to learn facts and generate new works, again, it throws a shadow across this really important precedent that we all, I think, have come to rely on as we think about what else is possible in digital scholarship. So just to take it one step further, if AI training must be licensed, then arguably so too must most digital humanities research projects, right? Like if crawling across in copyright material in order to analyze it and derive new works and new information, if that's not fair, I think again we could see a real retrenchment against digital research, because lots of digital research is based on that sort of method of data analysis across copyrighted materials. Another reason to worry about an adverse outcome of these cases is if AI training requires a license, then only the very biggest commercial entities are going to be able to develop AI tools. That means research teams who could use AI tools in their own work are going to face high costs to create those tools, high costs to license those tools. There won't be as much competition to develop tools. Even investigating and critiquing AI typically involves the same kinds of methods used to create AI. And so, again, if there's a kind of copyright shadow hanging over all of this activity, even critics and skeptics about AI will be chilled from doing the work that they want to do because they'll have to worry about whether copyright would prevent them from doing it. Just to put a fine point on it, again about the competition point, one of my main concerns is I think it's nice for OpenAI and Google and others to sort of say they're defending fair use, and I think they are. I think they do believe in it, but as you see in the headlines every day, they're making deals at the same time, and they can afford to make those deals, and they're getting so much money that in the end, it may well be possible for them to operate on a licensed basis. They say it's not possible. And that might be true, but as the technology gets better and as they get more and more money, they may be able to pay a license, but you won't. Libraries won't, researchers won't, new companies won't, and it locks in an oligopoly of sort of AI companies. AI tools would inevitably be biased in terms of the data they have access to, right? Because licensed data will reflect, who had access to professional publishing in the 20th century. And I know a lot of people who didn't, right? And so if licensed data sets become the only data sets that are available for training, then the perspectives of people who are represented in sort of professionally published materials are going to get much more weight than the perspectives of people who might be published elsewhere because, again, information you sort of find in other sources will be harder to license, may not be available to license, and companies will then skip over that data and not train on it, not use it as part of the information that it relies on. And then finally, and frankly, most importantly, Elsevier would make more money. And I think nothing, you know, that's my litmus test. Any policy outcome that involves Elsevier making more money is a bad policy outcome. And I guarantee you Elsevier is, chomping at the bit to license, and of course is already licensing all their data for AI type tools. And nothing would make them happier than to have a total monopoly over that stuff. So, okay, that's AI inputs. And I might pause there. Have there been any questions so far that we should get to before we move on? No.
I haven't seen any questions in the chat yet.
All right. Okay. So far, so good. Please don't hesitate. I'll pause. I'll pause after each little section. So if I say something that sounds crazy or weird or unclear, please do go ahead and ask a question in the chat, and we'll stop and answer it at the appropriate time. Okay. So outputs. Who owns the outputs of generative AI, and who is responsible for the outputs of generative AI? Um, Are generative AI outputs eligible for copyright? This is a really interesting and important question. Um, in copyright law, we have a kind of a body of case law that talks about the importance of human authorship. And so in the Constitution, Congress is given the power to give to authors exclusive rights in their writings. And so the courts have said in the past, for example, uh, uh, people have, believe it or not, in the grand sweep of history, so every crazy thing you can think of has probably been tried. And so one crazy thing that has been tried is somebody tried to register a copyright in the name of a divine creature. They said, well, I didn't write this book. It came through me from heaven, right? Or whatever. And the court said, well, that's great, but we don't give copyrights to divine beings. The divine beings are not human authors. Only human authors get copyrights. And some of you may remember a few years ago, poor Naruto, the monkey who took a selfie. And it's a great picture, which is why it ended up in court, because it was probably a valuable picture. He actually kind of smiled for the camera, and but a sort of wildlife photographer set up his camera in a way that this monkey Naruto was able to then sort of push the button and take pictures of himself. And again, the Copyright Office and the courts said, we don't give copyrights to animals. Copyright is only to reward human authorship. It's there in the Constitution. And not only is it it's not just merely a semantic idea. It's a question of the reason we give copyrights is to reward and incentivize creativity, and presumably human creativity. Humans who they have options in life. I could go be a banker instead of being a struggling playwright. So if I decide to be a playwright, copyright gives me an opportunity to make a living at that by selling my work. Monkeys are not motivated by copyright. They don't need exclusive rights. That monkey didn't take that selfie hoping that he would be able to license it. Divine beings, I don't know what motivates them, but presumably if it is in your divine agenda to be creative, you don't need a copyright to motivate you. And similarly, it turns out for robots. Artificial intelligence is not a human, does not, the creations that are purely created by artificial intelligence, the Copyright Office has now ruled, and courts have upheld so far, that pure AI creations are not eligible for copyright. And you see there one example, a recent entrance to paradise, which is attributed to the creativity machine, which is, again, there's a person, Thaler, who's a kind of a computer scientist guy who's a true believer in the agency of machines. And he says, "Oh, I didn't make that. The computer made it, but I want the computer to own the copyright in it." And the Copyright Office has rejected that idea. And most recently, as in like last week, the Copyright Office issued a report. Oh, I had it. I thought I had it on my desk. Its second report in a series of reports on artificial intelligence. And the Copyright Office went more deeply into its views on the copyright eligibility of works made with AI. And I think James Grimmelman, who's a really brilliant law professor at Cornell, had the most pithy summary of the report, which is if you make art with the help of AI, it's copyrightable. But if you ask AI to make art for you, it's not. It sounds, immediately the line drawing exercises, come flying at you fast but that is the basic distinction. Did you make the art using an AI tool, or did you ask AI, "Hey, make me some art"? Um, and of course, then the issue is going to be there are already dozens of hundreds of thousands probably of works that are a mixture of human creativity and AI creativity. And so, what will the courts do with those works? And I have views on that, but I see Karen's got her hand up, so I'm guessing we have a question. Yeah, go ahead, Karen. I think you're still muted.
I'm sorry. Okay, can you hear me now?
Yes.
Okay, we have a question in chat about with from Arthur Andrew Roner, where he says he's asking if not to interrupt the flow, but now corporations are persons.
All right. Yeah, interesting. Well, the corporations are persons in the for First Amendment purposes, and that's the holding in Citizens United, the sort of infamous. So for purposes of and then I mean really, Citizens United is a kind of it's a multi-layered. Corporations are persons, and also by the way, money is speech, and so voila political donations are protected by the First Amendment. But, happily, that level of insanity hasn't infected the copyright law yet. So we still actually, when we say human in the context of copyright law, we do literally mean, a flesh and blood, person with a beating heart. Now, it is interesting, corporations can be the legal author of a work. Created by, for example, a human employee. So if you work at the New Yorker or the New York Times or the HBO, everything that you make instantly legally is sort of legally authored by your boss. But that doesn't mean, but you still have to be a human in order for that copyright to sort of come into existence. Um, so what do we do about mixed works? This is actually not an unfamiliar question in copyright. Lots of copyrighted works are mixes. So for example, every film that I work on is a mix of original material to the director and their production team and pre-existing material that they don't hold copyright in. And so when we register copyrights in those films, we have to disclaim that third-party material. And so in the registration, you say, contains archival materials that aren't copyrighted, that weren't created by us. That's all you have to do. You don't have to give them a rundown. Like at 3 minutes, there's a picture from 1979, and at 5 minutes, you don't have to give them a detailed rundown. You just say, there's other people's stuff in this movie. And then if there's a fight about it, if somebody sues you or you sue somebody, then it may become an issue to litigate about. Well, you say, for example, a lot of my clients will get archival materials from other people's movies. That is, there may be a nice little bit of footage and they can't figure out where it came from. They aren't able to go to the original source, but they can pluck it out of a pre-existing film. And that's perfectly fine because whoever made that film doesn't own that little bit of footage. It's third-party material, right? And so if the director of the film that we pull that material from were to, file a complaint against my clients, the first thing we'd say is, well, this isn't yours. Like you own the movie, but you don't own that part of it. And the same thing will happen with AI. What we'll have is there'll be a lawsuit, and someone will say, you've infringed on the copyright in my work, and the defendant will say, but the part I took was made by AI, and you don't own that. That doesn't belong to anybody. And then there'll be a fight about it. It's okay. Courts know how to do that, actually. As I say, they do it all the time. Some people say, oh, this is going to be a litigation explosion. I don't think so. I think we won't see that happen, but time will tell. Who's responsible for infringing outputs? That is an Italian plumber fixing a toilet. That was, I think, the prompt. You may recognize that Italian plumber. His name is Mario. And that was like a year ago, I think. This is a more or less this was generated by James Grimmelman actually for an article that he wrote using, I think, Midjourney. Oh no, Stability AI. Um, and yeah, they didn't say make me a Mario, although later they said make me a Mario and it did. Or make me an Italian plumber in a video game and it looked even more like Mario because that's so there is this problem of AI sort of learning copyrighted characters, the Italian plumber problem. And so if I say make me an Italian plumber and it gives me this, what happened there? Who did it? Did I make the Italian plumber? Did the AI make this particular Italian plumber? Did we do it together? Courts are going to have to sort that out. Courts are going to have to sort that out. And one of the things they'll do is they'll think about what's called the volitional act requirement. So who pushed the button is one way of thinking about it. So in cases involving digital video recorders, the courts have said, well, in digital video recorders in the cloud, like you may remember a million years ago, TiVo, right? You could sort of record television, and it would be stored in the cloud. And somebody sued and said, well, all those copies in the cloud, TiVo did that, and they're doing it commercially, and that's not okay. And the court said, no, every recording is actually made by the user. The user pushes the button. The user is the one that says, I want to make a copy now. And TiVo just sort of follows orders. But, I didn't ask for Mario. I said Italian plumber. The AI gave me Mario. And again, the AI is making a lot more choices about what the image looks like than the video recorder did. So it's going to be interesting questions about who's responsible when these things go sideways. And one of the implications of that is AI companies are now creating what they're calling guardrails or filters, where if I say Italian plumber and the machine generates that image, before that image gets to me, there's going to be a filter that says, oh, that's a Mario. Don't give him that image. Try again, right? And so there'll be these sort of filters that ensure that the sort of infringing content doesn't come out. But what if I want a Mario? I think as a policy, this is really an interesting issue. I can draw Mario with my pencil, right? If I want to draw a Mario, nobody can stop me. And it would be really creepy if I sort of drew a Mario and then it disappeared because my paper said we can't, you can't do that without permission. But that seems to be the world we may be headed toward, to the extent that people use AI for creativity. What they're able to create will be policed in some ways by the people who own all of the IP that governs our culture right now. So I'm worried about these guardrails as a friend of fair use and an ally of sort of like creativity. Okay, now I get to really go crazy and bring it back to open licensing, which I apologize. I know that didn't get as much play in this talk so far as it might have been expected. But I want to talk about generative AI and scholarship. Um, there are a few different fantasies floating around, right? And I think we all know the publisher fantasy about how scholarship interacts with Gen AI, which is that the back catalogs of Elsevier and so forth are like super high quality data. This is the really good stuff. If your machine eats these articles, it's really going to be smart. I know, I don't know if it's gonna write well because academic writing is garbage, but it will know a lot of stuff. And that's really valuable stuff. So that's the publisher fantasy. Ooh, now our back catalog becomes even more valuable. My fantasy is that if the outputs of generative AI are in the public domain, then we could enter a world where lots of scholarship is generated by artificial intelligence based on inputs and training from scholars. But look, a lot of scholars anyway, now not my scholars in the world of English and philosophy, but a lot of scholars hate writing. They hate writing up their research. And if a machine could write up their research for them, they would love that. Um, and the nice thing about that, again, would be that whatever the machine wrote up would be immediately free of all copyright because machines don't get copyrights, you know. So we'd have zero copyright articles that are born into the public domain. Also, similarly, if we could crawl across an article, scholarly article with an artificial intelligence tool and create a summary or a restatement of the facts in that article in different language, that would be, again, in the public domain. And to the extent that we don't care about the prose so much as the facts in academic writing, it could be very interesting to think about how you could turn a bunch of in copyright articles into a bunch of public domain restatements. Um, and Jason Preem has a similar kind of fantasy that we could take artificial general intelligence AGI, which just the true fantasy of AI that's like basically a person. Um, you could simulate scientists, he says, in silico, meaning, you could sort of spin up 150 scientist level intelligences and say, go out there and find me the 5 best articles about this. And if they're crawling across, preprint servers, that's peer review, right? You don't need peer review anymore. You have these sort of super intelligent creatures doing their peer review for you in real time based on exactly what you want. And so journals really lose any relevance at all in that scenario. Finally, Gen AI and OER. Again, pure generative AI material is born into the public domain, right? That's my first premise. Like if you didn't write anything, but rather you asked the machine to write it for you, then that's a public domain creature. And so again, a sort of AI restatement of uncopyrighted factual material is a kind of copyright remover, a kind of information liberator. So you could, for example, sort of feed 7 chemistry textbooks into an AI and say, write me a good chemistry textbook that includes all of the information in those books, organized in the following way. Now, you'd have to hire a lawyer. I know a good one to help you sort out the boundary there. But I think what you might have there is a kind of a way of generating a new text that is born free of copyright using factual information from previous texts, which were never protected by copyright. Any one of us can, essentially a lot of OER creation is a matter of taking factual information that's locked up in old, paywalled materials as an expert, synthesizing that information and restating it in a new open package. Well, AI could do that sort of instantly, again, as Jason's sort of thought experiment suggests. You could spin up an AGI and say, write me a good OER about chemistry. Here's 150 chemistry books, and it would take 30 seconds. So very interesting possibilities there. Um, how do open licenses come into play? Well, one thing that OER has always been good for and is one of its core virtues is that an open resource can be adapted. It can be, changed to fit a new context, even though lots of adaptations raise copyright questions, So this is, when I say if you restate a chemistry textbook, you would need a lawyer to look at that to make sure that the restatement doesn't take any copyrightable aspects. But if you just want to translate, for example, from one language to another, or you want to create a version that's, more or less the same, but with some important differences, AI could again help you with that adaptation in real time. It can reduce the workload of doing it. And an open license would ensure that the resulting adaptation would also be free to use, right? It wouldn't infringe on the original. Um, on the other hand, license-based limitations, and this is another of the great lessons of OER, if you use non-commercial or no derivatives, you're kind of violating the five freedoms. And this is also true for AI. If you say non-commercial, no derivatives, etc., then again, the utility of an AI tool as a way of adapting or translating an existing OER, you gum up the works because the license will compel the person using the tool potentially to avoid creating the new work in the way that they would like to do. So, it may be fair use to train a tool in the background, but fair use will not allow the creation of new derivative works without permission. So an open license will enable it, but a license that's too closed will prevent it. Um, so I think, let's see, that is my last point, and by golly, we have 5 minutes left, so let's chat. And I will stop sharing my screen here. And I apologize, I talked too long. That was as I often do. But happily, many of you know me, and so you probably aren't surprised.
I think it has been amazing, um, all this information. Um, we would like, okay, yes, we have a question right now from Judith Thomas, and the question is, do you see any possible legal weight to preference signaling in copy protected works?
In terms of like for AI training, so if somebody says, I would rather not, I doubt it. I doubt it. I think it's very useful politically because I think the AI companies, the big ones, and frankly, in a way, the ones like most people are like scared of, and I don't want to be crawled by, OpenAI or whatever. They are very scrupulously following those kinds of signals. So, robots.txt, those ways that, we're still sort of, I think, coalescing around what that standard will be. I was at a meeting last week about this, and a representative, Microsoft really wants it to be robots.txt because it's a nice, simple standard that everybody knows, but other people think it's not granular enough. So we're still figuring out what the standard might be. But I will say again, the big companies are inclined to follow that signal if, once we figure out the best way to make that signal happen. But I don't think it has any legal weight, and I'll say boldly, I don't think it should. That is, imagine somebody who's doing research on, far right ideology, and they want to do a kind of large scale analysis of, the leaked chat sessions of some, big troll farm, right-wing troll farm. Um, it's quite possible that, the people who are writing that, they don't want you to do that research, and if they're in control of how that material is used, they'll say it, don't crawl me, don't use me to train AI. But I think as scholars, that makes me bristle. And people have tried to do that with books, 130 odd years ago. There's a famous case where a publisher put a note in the front of the book that said essentially like, this book can't be sold for less than $2. And the court said, no. I mean, like, you might not want it to be sold for $2, but if somebody buys it and they decide they don't want it, they can give it away, much less sell it for less than $2. So that kind of warning language has never been very effective in the past, which I think is good.
Um, Brandon, we have another question from Veronica Howard. And the question is the following. Given some of the recent and relatively unexpected rulings from the US Supreme Court, do you expect this may be a period of time when the stability of legal precedents around copyright, especially as they relate to emerging technologies, emerging technologies are a bit less solid than they have been in the past?
Yeah, no, that's a good point. It's a good point. And I do suffer sometimes from like expertitis. Like I am deep into fair use. I have read all the cases. And so to me, there is like a very strong legal the legal precedent on this issue is clear, and I think other legal experts, copyright experts have mostly felt similarly, but judges aren't copyright experts. Judges are general purpose, thinkers, and especially for goodness sake, the Supreme Court, it's a bunch of elected politicians at this point. So it is true that, it is dangerous for me to say, ah, ha, ha, we have all the precedent. What could possibly go wrong? And this is it is an unusual, it's literally a new technology. I mean, nothing like it has existed. So I think actually Google Books and How Do You Trust were very much like it at the level of principle. But, for example, the thing that could gum things up is that the creations of artificial intelligence can literally compete with the works they were trained on, in the sense that, like, on Spotify, you can stream, any one of a bazillion things. And if you stream this AI slop instead of streaming, Aphex Twin or whatever, Aphex Twin loses money to the slop. But the thing is, that's always been the case. Like it has always been the case that I can listen to all those records and then pick up one of those guitars and write a new song that sounds a lot like all the right. That's all I can do is write songs that sound like the ones I've heard before, and that's okay. Like we've never before said it's bad to make a new work based on what you learned from old works. That's not the same as copying from an old work and republishing it. That's the big difference. So you may train a tool that creates competing works, but if the competing works are new, that's never been a problem before.
Thank you so much, Brandon. We are out of time. So I want to remind everybody that you will receive an email shortly with a brief evaluation form of this activity. So we will kindly ask you to complete it. And I really thank you all for being here.